Hello and welcome to Newsnight's Deccan Vahini and Jisha Surya. Governor versus LDF Government. Over the last few months, this battle has been making headlines across Kerala, and this issue is being widely discussed by every Malayali and across India. Ever since Arif Muhammad Khan assumed office in September 2019, Raj Bhavan and the Secretariat have been at loggerheads over one issue or another. In the latest flare-up, the LDF government has come up with an ordinance that could remove the governor from the post of Chancellor. The CPM has also launched a major protest against the governor who, according to them, is executing Sangh Parivar agenda in the state. Governor, on the other hand, says that he was opposing the irregularities in appointments and issues of nepotism. Constitutional expert PDT Achary has joined us today to discuss and help you better understand the legalities of matter, who is right, who is wrong, and how it's effective. Is the former Secretary General of Sabha. Thank you for joining Newsnine's Deccan Vahini.
Thank you.
The latest development in the government tussle is an ordinance that proposes to remove the governor from the post of Chancellor of Universities. Now, the governor is saying that he is not going to give the assent to this ordinance, and he might also send it to the president. And the government, on the other hand, is saying that if that's the case, they will approach the Supreme Court. So what are the constitutionally viable options ahead of the two parties in this issue?
See, so far as the government's decision to amend the law to remove the governor as chancellor, the government is well within its right to do that, because chancellor's post is a statutory post. That means that post is created by a statute passed by the assembly, and therefore the governor is holding this position in ex officio capacity. So, through an amendment in the law, the government can certainly remove the governor from holding this ex officio position, and they can provide for the appointment of some experts as chancellor. So, the point is, removing the governor as chancellor is not a horrendous kind of act as it is being made out by some channels. That is not how it is. Governor is not being removed anywhere. Governor is governor. But he will not hold the position of chancellor after this law is passed and assented to by the governor. And that, according to me, is a normal legislative measure. There is nothing extraordinary or horrendous about it. Of course, governor is holding this position in ex officio capacity because of the law. So the law provides that. And if the law provides otherwise, then that this is a hereditary position, or it is something which has been given to a particular person. The chancellor's position is not personal to the governor. Let's not be under any kind of illusion so far as this law is concerned. And therefore, the government and the assembly are well within their rights to do this or bring any other kind of amendment. The only thing is that such amendments should not be against the Constitution. That is it.
Okay, so one major question being raised is that when the state government intervenes or take charge of the power, it will affect the autonomy of the institutions. They say the governor, chancellor, as a chancellor, it is not a political appointment. Now it is being, the other argument is that chancellor is a political appointment. And nowadays he is exercising his power in that way. So these two arguments are coming up when the state government is involved, and also when chancellor is involved. It will affect the autonomy of the universities. What is your opinion on that?
Well, it's a little difficult to understand when somebody says that if the governor is holding the position of chancellor, there will be autonomy, and the moment the governor goes and somebody else takes over as the chancellor, then the autonomy goes out the window. That is not an argument which can be accepted. There is no logic in that. That is it. Autonomy of the university is provided for in the Act, the University Act. And all provisions have been made for the autonomy of the university. What is the autonomy of the university? Autonomy is practiced in the academic field. And look at all the provisions relating to the academic aspect of the university is running. You will find all the government's interference is negligible. Whereas in the composition of the Senate, in the composition of the syndicate and things like that, there are any number of government officials who are holding positions or membership of these two bodies in ex officio capacity. And then the government, after all, this is a legislation, this is an act, this is an institution which has been set up under an act passed by the assembly. And the universities report the accounts, the financial things. These things have to come before the assembly. And the government gives grants which is sanctioned by the assembly. So one cannot say that the government should have no control at all. Government does have control in the administration, in the financial management of things. Government has a say. But it is not a day-to-day, it is not an interference in the day-to-day administration. If you look at the scheme of the University Act, you will find that Vice Chancellor is the head of the executive administration of the university, and also he is in charge of the academic area. So he coordinates both the things. But then he can coordinate things only in accordance with the law. And law makes elaborate provisions for the academic autonomy of the university, or this university or any university. That's how it is. So that argument, I don't think it doesn't wash. That's it.
Okay. So Kerala is not just facing this issue of this just one ordinance. Certain other bills are pending with the governor. How long can the governor withhold these bills?
See, there is a lot of confusion with regard to this point. How long can the governor keep a bill without signing or without taking any decision? I have said it umpteen times that a governor cannot do that, because the Constitution, particular Article 200, it actually provides 4 options to the governor. One is you assent to the bill. The other one is you withhold assent to the bill. Or the third one is you send it back to the assembly, asking them to reconsider it by some provisions or the bill as a whole. And the fourth option is to send it to the president for his, reserve it for the consideration of the president. These are the 4 options given by the Constitution. Now, see, it doesn't require any kind of research to know that when the Constitution provides 4 options, the governor is required to exercise one of these options. And sitting over the bill without taking any decision is not an option given by the Constitution. So, ignoring all the 4 options given by the Constitution, if the governor does something which is not an option at all in the Constitution, given in the Constitution, then do you think that that is constitutionally valid? According to me, it is not. You are exercising an option which is not there in the Constitution. That is it. It is true that there is no timeline fixed, but you cannot take advantage of that. There is no timeline fixed. They did not fix any timeline because here the parties involved are the high constitutional authorities, and the constitution makers perhaps thought that it is not necessary because they will act only in accordance with the Constitution or the spirit of the Constitution. Perhaps the constitution makers could not have visualized the kind of situation that the states are facing today.
So what is the option in front of the state government to deal with this issue?
See, the point is, one is, as I explained just now, if the governor commits undue inordinate delay, he doesn't do anything, and he keeps quiet, he sits over it for inordinately long time, then the government can certainly approach the court. Although this issue has not come before the court has not given any particular decision on this point, whether the governor can sit over the bill. There were some decisions earlier which suggested that perhaps the governor, this is not justiciable, but that is no longer the correct position. Because new situations have come up. After all, you must just look at it. A bill is passed by an assembly. It is not for the fun of it. A bill is passed because there is a requirement of a law for a particular thing. Okay. And that is in public interest. After all, government, any government, legally constituted government, is the custodian of public interest. So when the government brings a law, the government is acting in public interest. And that is brought before the House. It is thoroughly discussed, and the members of the assembly have expressed their views, and they vote for it or against it, whatever. Majority of the people have voted for it, and it has been passed. And after that, a governor, who is just an appointee of the union government, he sits over it and throwing to the winds the constitutional scheme or the constitutional mandate. How is it possible? I mean, can it be countenanced? Can it be accepted? So that is the problem.
Right. So it's not just a matter of Kerala. A lot of other non-BJP ruled states are exploring the possibility whether they should have this post of the governor. How do you view these discussions?
Well, that debate perhaps is no longer there. I mean, there was a time when people used to, some political parties used to say that we don't need a governor. Why should we have a governor? But that issue is no longer relevant. You have a governor and you will have a governor. So there is no point in taking up that debate again. But the point is, how will the government conduct himself? That is the crucial point. Whether the governor will recognize the line, the Lakshman Rekha, or whether he will, at his will, whether he will cross the line whenever he wants. So that is the question which needs to be settled, which needs to be decided. And that is the question which has come up in all these cases. Governors are not acting in accordance with the constitutional scheme. Governor has no authority. He is a constitutional head, means he doesn't have executive authority. He can the executive authority is vested in the elected government. So he has to act on the aid and advice of the elected government. That is how it is. And a very large number of cases have been decided by the Supreme Court defining the powers of the governor, starting from Shamsher Singh to Nabam Rabia. So, what is the point to be decided here? All these matters have been settled through these various judgments of the Supreme Court.
Okay. Okay, sir. Thank you for your valuable insight into this topic. We know that a lot of discussions are happening around this subject, and I hope our discussion will bring a little bit clarity to the topic. Thank you for joining us, Deccan Vahini. Thank you, sir.